Hi, everyone. Welcome to the annual meeting for the American Society of International Law. Our panel today is on Accomplice accountability for grave violations of international law. We have an amazing group with us here to talk about these issues. If you're here, I'm sure you know that the most egregious examples of international law violations that have threatened peace and security in recent times reveal a common trend, that is that governments are perpetrating these serious crimes not entirely on their own, but acting with and through others. They often do so with the help of other states or with the help of non-state actors. For example, I will be talking about this today, but the United States, UK, France have provided logistical support, weapons, and other kinds of intelligence support to the Saudi-led coalition, whose airstrikes have killed numerous civilians in Yemen. There's also been almost a decade of Russian and Iranian air and ground support for the Assad regime's systemic torture and killing of civilians in Syria. And also in Syria, the United States has partnered with non-state groups in Syria, most prominently the Syrian Democratic Forces. And Iran is known to partner with non-state actor groups throughout the Middle East. So this is an issue with many different dimensions, highly complex, and we're going to try to tackle as many pieces of this as we can. So the panel is going to explore the range of issues raised by this indirect participation in conflict. It'll ask what accountability is warranted under international law, what legal responsibility should potential accomplices bear for their role in grave violations of international law. And we have with us today 5 amazing speakers who will work with us to try and think through these issues. They're complicated and important, and we have a great group here that will help us think it through. So I'm going to introduce them each individually, and as I do, I'm going to ask them each a question or two, and we're going to go through each of our great speakers, and then we're going to wrap up in an hour, which is much too little time for taking on this complicated topic. But there's a continue the conversation event after this panel that we hope many of you will join to be able to speak with our panelists and speak with one another about these important issues. So first, I'm going to introduce Catherine Gallagher. She's a staff attorney at the Center for Constitutional Rights, where she works on holding US and foreign officials and corporations, including private military contractors, accountable for serious human rights violations through domestic civil actions, criminal cases under universal jurisdiction laws, or at the International Criminal Court, and actions using United Nations human rights special procedures mechanisms. Prior to joining CCR, she worked at the International Criminal Tribunal for the former Yugoslavia. So, Katie, here's my first question to you. You have been involved in the long-running case of al-Shamari v. CACI, brought by the Iraqi Abu Ghraib torture survivors against a private contractor, CACI Premier Technology. Can you tell us a bit about that case and what it means for the capacity to hold government contractors who aid and assist grave violations of human rights accountable?
Sure. Well, first, thank you for having me. And it truly is a privilege to be on this panel with my co-panelists, who I'm eager to hear. As you said, this is a long-running case, so I will be speaking briefly about efforts for accountability at a slice of the harm done at Abu Ghraib, which many of those watching may remember when they first saw those photos come out back in 2004. So we're talking about a long time ago now. And throughout the last 16 years, victims have been seeking accountability. So a short answer to your question, Una, is it's not easy. al-Shamari v. CACI, or CACI, is the third case brought by Iraqis who were tortured and otherwise harmed while held in US detention across Iraq. The al-Shamari case focuses only on the hard site, which is the location where those infamous photos were taken. And it is brought now on behalf of 3 men, Mr. al-Shamari, Salah, and Assad. The reason why this case was brought against private military contractors, and CACI in particular, is when those photos came out, it was followed by the Taguba report, which some may remember. This was a internal report done by General Taguba into harms in U.S. detention centers in Iraq. And he found that there were, quote, sadistic, wanton, and blatant crimes committed against Iraqi detainees. And he identified two of the private military contractor companies' employees as having been complicit in that harm. The companies at the time, Titan, which ultimately became L3 and then Agility, that was a party to our first two lawsuits, and we settled the case against L3 back in 2011. CACI has been a defendant in the first case, Salah v. Titan, and then now, of course, in El Shamari. CACI provided interrogators at Abu Ghraib in that hard site. And what the Taguba report identified and what we have subsequently found through years of discovery, including relying on court-martial proceedings by the small group of so-called bad apples who participated in the torture and other abuse of Abu Ghraib detainees, what we found is that some of the CACI interrogators were in fact ringleaders. They came in, the contractors came in, oftentimes they were older than the enlisted US military. They were paid sometimes 3 or 4 times as much as a soldier, and they came in with a sense of authority. And in this command vacuum, which was found to exist at Abu Ghraib, they filled that space. And what they did is they encouraged the military police to, quote, soften up detainees ahead of interrogations in the hopes of having the detainees broken such that they would talk. Now, over the course of these many years, I've represented 338 Iraqis who had been detained. None of them had ever been charged with a crime. So this softening up and this harm was not only illegal, it was also pointless. And so 3 of the individuals in this case have been trying for the last 12 years to have that company, which profited handsomely from its work in Abu Ghraib, held accountable. And as I can say in a follow-up, it's proved quite challenging.
Yeah, I did want to follow up to ask you to say a little bit more about what the legal claims are that you've made. Sort of what are the elements of the legal claims, and what have you found in terms of what has been successful and what kinds of roadblocks have you run into?
Sure. So the plaintiffs brought first a set of common law claims, which we've since dismissed, and also claims under the Alien Tort Statute, the ATS. They brought claims of torture, war crimes, and crimes against humanity. And I should say, when this case was filed back in 2008, it was before Kiobel, it was before Jessner, and it was before whatever the Supreme Court decides to do with the ATS in Nestle. And so we are hoping that corporate liability for domestic corporations continues. The claims really come from the severe physical and mental harm. And I would really highlight the mental harm. And I think that's relevant to the theories of conspiracy and aiding and abetting that we are advancing. So what we allege is that the private contractors, the interrogators, worked together with the military police and other members of the military intelligence to, again, break the plaintiffs. And one of the things CACI has said over the years is, well, we're not the ones who physically beat and harmed or tied up or stripped naked your plaintiffs, so we didn't touch them. And in these theories of conspiracy liability, which has an analog in international law of joint criminal enterprise, and we've pointed that out, or aiding and abetting, substantial assistance that has a significant effect on the outcome of the crime. And there's been some debate as to whether it's knowledge or purpose. We've said we meet whichever that standard is, because when the contractors went to join with the military police, they could be outside the room. They could be speaking to the military police before or after the abuse was done, because they are trying to mentally break down our plaintiffs. The contractors have raised an array of defenses over the last 12 years, from government contractor defense, essentially saying everything we did, including that torture the government told us to do, or derivative sovereign immunity, which is an issue that came up most recently, and plaintiffs have prevailed on all of these issues, where the contractor has tried to impugn upon itself some of the immunity of the sovereign, if that immunity even exists. So there have been questions about the legal standard, what are the facts that support the claim, and then a range of defenses. But we have made it through all of those stages, including summary judgment, and we had a trial date before this issue of derivative sovereign immunity went up on appeal, and we now have a cert petition pending before the Supreme Court.
I wonder, and my last question for you would be if you could kind of scope out a little bit from this case to more generally the government contractor cases. My understanding is that there's been a number of these cases against government contractors, particularly in the United States. And are we seeing sort of common themes being sounded across these cases? I understand there's one relating to the wall, or I think related to some of the issues at the border, so are there similar kinds of defenses being made, similar kinds of claims? Do you think these are going to rise or fall together, or are they distinct enough in terms of the kinds of claims that are being made across these different cases, such that the hope is that even if one runs into trouble, the rest of them are likely to at least continue to have a possibility of proceeding?
Yeah, we are seeing I wouldn't necessarily say a rise now, but another crest of a wave, because we had a series of cases that came out of Iraq and Afghanistan and US military interventions there. Those were the most outsourced wars in US history. And of course, under the Trump administration, we saw even more privatization. So we do see a increase in cases domestically as well as internationally, whether it's in private prisons or in detention centers, or in building things like the wall, or other ventures where human rights are violated. And so I think this is an area that deserves greater study and attention. And a kind of a brief answer to your question, which could have a lot of permutations, at least what we saw in the context of Iraq and Afghanistan, is in the case of torture, we are alleging intentional torts. And we are also alleging a violation of US statutory law and core tenets of international law when we're talking about torture and war crimes. And so that there really could not be the defense of the government made me do it. This is very different than the original government contractor defense case that people may know of Boyle, where private companies were building things like helicopters or providing other services that on their face are not unlawful or don't sound in intentional torts, but really in negligence. So I think it really depends on what the harm is, whether it's a negligence-based claim or an intentional tort, whether you're talking about violations of Hughes-Kogan's norms, such as torture. But that could certainly be the case in things involving things like slavery, where you have forced labor in prisons, or family separation. So I think this is an area to watch.
Fantastic. Thank you so much. So I want to turn next to Ibrahim Al-Qassem, a Syrian lawyer who focuses his work on cases to support detainees before the Syrian Terrorism Court. He's founder and member, or the founding member of the Caesar Files Group, and has worked as legal consultant to the UN and for the Raoul Wallenberg Institute of Human Rights and Humanitarian Law. Currently, he's supporting the European Center for Constitutional and Human Rights as a research fellow focusing on war crimes in Syria. And Ibrahim, the Syrian conflict, which I mentioned at the outset, is one that has been fueled by outside state involvement. Russia in particular has been involved in propping up Assad's government and helping it survive. Many believe that Russia has not only committed humanitarian law violations, but aided and assisted Syrian violations as well. And there are obligations under the laws of state responsibility not to aid and assist internationally wrongful acts by other states, and obligations, of course, under the Geneva Conventions, not only to respect the conventions, but to ensure respect under Common Article 1. It seems that these rules have not been adequate to dissuade states from supporting some of the gravest violations of international law. Can you speak about this problem from your perspective, and what, in your view, can be done to address these really grave problems?
Hello, thank you, Anna, and it's my pleasure to be with you. Actually, the Russian intervention takes many forms of intervention in Syria. Last week was the start of the 11th years for Syrian liberation and the Arab conflict, which witnessed one of the greatest tragedies in this century, actually, because we have a lot of hundreds of thousands of victims, many of them children and women, more than 12 million refugees and displaced persons inside Syria. And in addition, also hundreds of thousands of detainees still and with still in detention, and nobody knows about their fate. Actually, whoever bears responsibility for more than 90% these crimes is the Syrian regime, along with Russia and Iran. Actually, the conflict is being fueled by intervention of several foreign states. But the most engaged intervention is the Russian intervention, actually, in propping the Assad government and helping it survive by direct participation in military operation through aerial bombardment and direct combat action, actually. Besides that, Russia has been involved in the appointment for officials in the Syrian government, army, and security agency, actually. On the other hand, the Russian representatives are also directly engaged in the peace negotiations between the Syrian regime and the opposition in Asitana peace talks. Moreover, also in 2015, in August 2015, because of the regime's loss of the control over large areas in Syria in favor of armed opposition, and it was impossible for the regime to continue without direct military support from Russia. Russia signed with the regime an announced pact. This pact states, firstly, Russia could send soldiers to fight next of the Syrian army. Secondly, gave the diplomatic capacity and immunity for the Russian soldier if they committed any crimes in Syria. And thirdly, Russia benefits a wide range of power and authority in the areas under its control and exempted the tax obligation in this area, in Syria. And also Russia, through its representative negotiators directly with the armed opposition on Syria, opposition groups on Syria, for a handover of areas and the reconciliation with the Syrian government. These agreements between opposite and the regime included protecting civilian people, actually, but civilian people from pursuit by the Syrian army and security agency. But and in addition, also establishing Russian office and hotline to receive civilian complaints about violation by Syrian governmental agency. But in fact, nothing happened like this. Nothing changed from Russia. Nothing, no act from Russia. And also, although Russia has been given all this wide range of power and authority and has been heavily engaged in the Syrian conflict, it hasn't fulfilled any responsibility to protect civilians from the violation in Syria, which committed mostly, as I mentioned in the beginning, from the Syrian regime. And beside that, we are now facing the crimes from the Russian soldiers themselves, and Russia didn't do anything to protect civilians from these attacks. Besides that, we are talking about Wagner group now, which working interest for the regime and Russia itself. Nothing happened from Russia until now. And all what Russia said that claiming that no responsibility and maintaining that its fights in Syria it's against terrorist groups such as ISIS or Jabhat al-Nusra. And at an international level, Russia did more, actually, additional things. that when she, especially in the UN, when Russia together with China used the veto power in Security Council multiple times in interest for the regime, actually, support the regime. Primarily by vetoing sending the assistant in the form of humanitarian aid for Syria. In my opinion, reason for the failure for the international committee to stop Syrian tragedy it's not just the Russian veto in Security Council. Also, beside that, the international committee didn't take responsibility, such as to find by obligating the Syrian regime to implement Security Council resolutions, such as Resolution 2245. Which calls for cessation of fighting and establishing of transitional governing body. All of that. Beside that, the international committee said policy which said dependent on what's goes in Syria, stay in Syria. The policy for international committee depends about the what happened in Libya. They justified the maintaining this by the intervention in Libya caused more deaths. But actually, we can repeat it this simply. If we look for the Bosnia, the intervention in Bosnia was better than not intervening. So the international committee didn't do also its responsibility. Finally, I believe that Russia and Russian and Chinese veto is not enough excuse for international committee actually, because most of the international military intervention alliance took places outside Security Council. Why is there no international coalition for humanitarian, for medical, or even for judicial intervention outside this council? In my opinion, also we need to reconsider the concept of sovereignty and to expand the concept of humanitarian intervention and make it's more effective in cases like Syria, so that the pillar of international doesn't affect the protection of civilians.
That's very helpful and of course incredibly depressing, though not a surprise. Sadly, the situation in Syria has been such a dire one. And you got to this a bit at the end, but just in the brief time that we have, you said very briefly, that you would like to see reconsideration of sort of absolute protection of sovereignty. And you mentioned also sort of more aggressive humanitarian aid and judicial and more judicial involvement. I wonder if I could ask you to say if there's like one reform that you'd like to see actors outside of Syria take to hold to account not just the Assad regime, that kind of goes without saying, but also in particular those who are supporting the Assad regime. And let's for now just focus on Russia since we've spoken the most about it. What would you like to see the international community do when it comes to Russia? Do you see any accountability for Russia or any possibility of accountability for Russia? And if so, what, in your view, would that look like? And again, I'm sorry, I'm not going to leave you a lot of time because I want to make sure we move on, but I just wanted to see if you had a thought on that point.
Yeah, actually, we are now in Europe. We are following or working in prosecuting many war crime and criminal war in Syria. In Germany, Sweden, Austria, Norway, and other states also. Regarding Russia, we are looking for bringing Wagner Group for the justice. But this is because of the national jurisdiction and extraterritorial jurisdiction. We have these challenges. In my opinion, we can find like this coalition for judicial by many European states, by support from the USA or Canada or other states, to find like tribunal to prosecute all this criminal in Syria, even Russian or others. We don't need for Security Council. We have like example for the IIIM, this mechanism which established for investigation on Syria crimes and to collect evidence and building files. When the Security Council failed many times to because of the Russian and Chinese veto to bring the Syrian case before the ICC, the solution was go for a General Assembly to establish this mechanism. So we have another solution, but it depends about how the willingness for the states to find solution for stop these crimes in Syria.
Well, thank you for that. And I hope we can circle back to some of these questions because I think they're relevant to several of the other issues that we've talked about. So thank you for that. So next, I'd like to turn to Radia Al-Mutawakil, a Yemeni human rights defender. She's a chairperson and co-founder of Mutana, Organization for Human Rights, a Yemeni human rights NGO that advocates for human rights through the verification and documentation of violations, provision of legal support to victims, lobbying for accountability, and otherwise seeking justice for victims. Radia has been working in the human rights field since 2004, covering different topics, including war crimes, arbitrary detentions, and forced disappearances, and freedom from the press, freedom of the press. So Radia, you've been working on the ground in Yemen. Like the Syrian conflict that we just spoke about, the conflict in Yemen is marked by significant external involvement. The Saudi-led coalition, which is supported by the United States, has engaged in a number of well-documented violations of international humanitarian law. Iran has supported the Houthis, who also engaged in human rights and international humanitarian violations. Can you tell us a bit more about the way in which violations in Yemen have been fueled by these assisting states and about your efforts at Mutana to find international mechanisms for accountability? What do you think can be done to strengthen international mechanisms for criminal accountability for accomplices in situations like Yemen?
Thank you, Anna. Happy to be with you today. And actually, that all violations that is committed by all parties to the conflict, local, regional, and international, is supported by the allies. You know, because because the war in Yemen is not only a civil war; it's also a proxy war, and there is also an international dimension. So this helped the violence to increase and the range of violations, the types of violations to be much more than if it is only local conflict. And it's the first time that we used to in Yemen to have different small wars. This is the first war while the whole Yemen is affected and thousands of civilians have been affected by the direct violations like airstrikes, ground chilling, and landmines, and other types of violations, and the violation of starvation. And we keep saying that Yemenis are not starving; they are being starved. So it's every Yemeni is affected by this war in every provinces, and the problem that each group thinks that they are hiding behind their allies, and this make them more or careless when it comes to violations. Most of the violations in Yemen are very prevented. For example, that Iran claims since the beginning of the war that they are not supporting Houthis. They are not even part of the war. And Saudis keep saying that they are supporting Saudis, the government, the Yemeni government. And the United Arab Emirates, they said they have withdrawal from Yemen while they are still supporting different armed groups, including the Southern Transitional Council. So they think that they can hide behind these local groups, and the local groups themselves, they think that they are empowered by their allies. So that helped in general to make the level of violence much higher in Yemen. And this three dimensions of the war in Yemen complicated all the efforts toward accountability, because also Saudis and Emiratis, they are engaged in arms trade with states like the US, UK, and France. This made like financial and political interest that made the war more complicated. And one example to tackle that is that to have like any kind of international investigation in Yemen. Although the war started in 2014, and it is very clear that all parties to the conflict are committing horrible violations, but we needed a lot of time in order to have any shape of investigation, international investigation, we could finally have a shape of investigation out of the Human Rights Council in 2017, which is the GEE. And it is a very difficult battle every year to renew the GEE or even to strengthen the mandate of the GEE. It's only because the regional Saudis and Emiratis, they have their own allies in the council, like the UK, as I said, and France and the United States, and they made it very difficult. While maybe it's less difficult when it comes to Syria, because they are all against al-Assad and they want a shape of international investigation, but they don't want it in Yemen. So they made it very complicated in this level. The very good work of civil society and the states who pushed for the succeed at the end to have a shape of international investigation in Yemen, but we still don't have the tribal IM. And also, like Syria, referring the situation of Yemen to the ICC is very complicated because of the veto problem, and because those who are doing veto, who have the right to do veto, are also engaged with financial and political interest with regional parties to the conflict who are involved in the war in Yemen. In the middle of this, we still think that accountability is the main thing that will protect civilians in Yemen, and the main thing that can push for peace in Yemen. And we know that Yemen is the worst humanitarian crisis in the world because of the huge lack of accountability. We are trying in Muwatana to push for accountability, not only through our investigation in the ground, but also we started to search what are the available mechanisms for international criminal accountability. As Ibrahim knows, and everyone maybe knows, it's very limited internationally, the mechanisms for accountability. So we were surprised when we discovered that the whole world is designed in a way that enhances impunity more than accountability. But we know it's not a destiny, and we can work in order to find ways to criminal accountability. We filed in Muwatana like a complaint in Italy because in one of the incidents we could find a Italian weapon in an airstrike where civilians were killed with ECCHR and Retreatist Armo, and also with ECCHR and other international NGOs, we submitted a communication to the ICC. But all of this is still from the angle of weapons. But we want to find a mechanism that can target all parties to the conflict, local, regional, and also international. And we are still working in this. And one of the demands what we started to do advocacy for is to refer the situation in Yemen to the ICC, and also to have a tribal IM in order to lay the ground of having files that can be used in the future for accountability.
Great, that's incredibly powerful, and also kind of lays the groundwork, I think, for what is a kind of common theme of the challenges that we're hearing here, which is the challenges. Obviously, you can't get justice in the country itself, and then the access to the ICC is so restricted given the limited scope of jurisdiction, that it's only states that are party to the ICC or crimes that are committed on the territory of the ICC, or if there's Security Council referral of the situation to the International Criminal Court, which is obviously subject to veto by the permanent members. So that's going to mean the Syria situation is not likely to be referred given the Russian veto, and the Yemen situation is challenging to get that referred, given the involvement in various ways of the US as a sponsor for the Saudi-led coalition, not to mention the UK and France. So then you're left kind of trying to figure out what are the alternative mechanisms. And you mentioned seeking jurisdiction in Italy against weapons manufacturers in Italy. And have there been other cases like that? Or are there places where you're finding, I know that for the Syrian conflict, and this may be a question that we'll come to at the end as we try to sort of wrap some of these up. But for the Syrian conflict, there have been some cases that have been able to proceed in European domestic courts, where you're able to find people who were responsible for various grave human rights violations, who then are found in other countries, and you're able to bring prosecutions against them in Germany, for instance. Switzerland, I gather, has been another place where there have been some cases like that. Is that something that is possible in the case of Yemen, or is it just so time consuming and just so difficult to like find the few places where you can get jurisdiction over someone or to bring a criminal case against them that the effort is not worth the challenge? Are you really still focused on trying to find some way to bring more generally these cases for accountability, both for state and non-state actors?
Thank you for this question, because for the universal jurisdiction, we've also discussed with our allies if we can use it in Yemen, not only regarding weapons, but also regarding other kind of violations. So the first question that we have been asked, do you have a Yemeni diaspora in Europe? The problem that there is no Yemeni diaspora in Europe. So the victim is in Yemen and the violator is not in Europe. That made it more complicated than the cases that happened in when it comes to Syria. So it's not impossible to still build files but it's very complicated. And we are still discussing this, and we are ready to go whenever there is a line that we can go for. But we have been told that it is very complicated to do it while you know that the victim is not there and the violator is not there also. And for we have also did a lot of work in the UK, and we sent a letter to the Secretary of State. We didn't bring like a case there because CAT is doing this already, and we have discussed with them, and we thought that it's better that they keep doing what they are doing and we can support in a different way. The problem when it comes to weapons, that if we don't have remnants of weapons, that proves that this country, the weapons of this country has been used in this incident, so it's more complicated. So it was easy in Italy because we could find remnants of weapons, Italian remnants of weapons. In France, we couldn't find remnants of weapons. In the US also, we found many remnants of weapons, but the legal story in the US is very different and more complicated, and we are still also trying to find ways. So that's why I said that it's very limited. But as I also said, it's not a destiny. We are still keen to use the universal jurisdiction, to use any kind of legal mechanism in the US, and we're still discussing this. And we're still discussing if it was the work, the journey, what is the last result of it, if it is something serious, or because when we want to criminal accountability, we mean it. We don't do it for advocacy. We do it for justice. So we want to be very serious in order not to renew these mechanisms. So it's very limited, but we're still thinking. And I think that we learn from Syria. So any kind of mechanisms that is created, for example, in Syria or Myanmar or any other country that who are facing war crimes, we try to read it, study it, and take benefit from it that can be used in Yemen. But it's a very long journey, and the international humanitarian law itself, although it's great, but itself is still sometimes make accountability very difficult. Like the idea of you have to prove the tension. It's almost impossible. And I don't know why it's there, but it's there in the international humanitarian law, and it makes everything more complicated. When we started to document for the starvation, it was very difficult for us to prove the link. We are now investigating this, and we're trying to see the pattern and the systematic kind of violations that led to starvation. But it's very weird that it's very easy for parties to the conflict to commit the crimes, but it's very difficult for us to bring it to courts.
That is sadly a all too common problem, and I think the frustration you're articulating is a frustration that is true, generally speaking, when it comes to human rights. And I think this particular problem that we're focusing on of accomplice liability makes it all the more frustrating when you've got actors who are from states that at least formally celebrate these principles of human rights and humanitarian law, but then are assisting these states that are committing these violations and sometimes even directly committing these violations themselves, and the frustration of the difficulty of bringing those accomplices to justice is a real one. And I mean, the hope is that conversations like this can help us find ways, lessons that one can draw from various efforts to try and address these challenges in one context, might be able to learn something from the other. And I gather we have many people watching this, so I'm hoping that some of our listeners and viewers, I think there are close to 200 of you, have ideas. And so hopefully to continue the conversation after the session will allow us to maybe trade some thoughts. Before we get to that, though, I want to turn to Dr. Welton Chang, who is the Chief Technology Officer at Human Rights First. Prior to joining Human Rights First, Welton was a senior researcher at the Johns Hopkins Applied Physics Laboratory, where he led teams and developed technical solutions to address disinformation and online propaganda. Before that, Welton served for nearly a decade as an intelligence officer at the Defense Intelligence Agency and in the Army. So Welton, I'd like to ask you to speak with us about the role of new technologies in assessing violations of international law. There are dual-use technologies that present challenges when they fall into the hands of governments that do not respect rights. Of course, for example, the Israeli company NSO Group spyware was used by the Saudi government to track Jamal Khashoggi, and the company Sandvine's deep packet inspection technology was used to block internet communications during protests in Belarus. Hawaii and others who built facial recognition technology that identifies Uyghurs who are then subject to persecution by the government. Can you say a bit more about this problem, and can you offer advice for companies, technologists, and governments for steps they can take to address this problem? Since you're not a lawyer, I won't ask you to talk about how to hold them to account, but we've got some lawyers here who may be interested in thinking about that problem. But can you kind of fill us in, help us think about this problem and what technology companies should be doing to try and address it?
Yeah, and thank you, Una, for leading this panel, and thank you to my fellow panelists for their insightful commentary thus far. I'll try to break my comments into two parts. I think it's worth thinking about how we got to where we are today, and then what should be done about the current situation. We're pretty far from the world and the spirit of the 80s and 90s, when there were widely shared beliefs that technology would be a great equalizer. That the internet's ability to connect anyone, anywhere to anyone else would enable massive diffusion of knowledge and spread of democratic values. I think part of where we went wrong is that techno-utopianism didn't really take into account the incentive structure of capitalism. One thing that the technologists did get right, however, was that the world would be very different as a result of the internet data boom enabled by ever more powerful computing resources, ever cheaper storage, and advances in things like machine learning. The ability to build, field, and abuse technology to commit large-scale human rights abuses has never been greater than it is today. I think we should state that technology itself has no inherent morality to it, and can thus be used for good or ill. There are legitimate uses for many of the tools that have been abused by actors like the Saudi government, and things like facial recognition and the knowledge of how to produce such technologies have proliferated to the point where just trying to institute an outright ban would be neither useful nor possible. One of the comments that Radia made about there being, I would say, a morass when it comes to US law, I think also applies in this instance, where Section 230 of the Communications Decency Act provides a liability shield for US social media companies. And to the extent that these companies have been very, very successful overseas, essentially the plaintiffs in those places have to contend with US law in order to hold those organizations accountable here. For example, Facebook's participation in the genocide in Myanmar, and Facebook being a company that essentially is the internet in many different places around the world. Because of Section 230, essentially, the people who are the victims of governments using Facebook as a tool, they don't really have anywhere to turn. And that's a direct result of basically American citizens not using their ability to vote and to influence policy to change that liability shield and to put people in place so that there are common sense carve outs for those rules. Some possible remedies that are not necessarily legally based. I think for companies should think about adopting ethical use guidelines and to consider setting aside their profit motive for just a second and not selling to countries or companies that they reasonably think would abuse that technology for either targeted or wide-scale human rights abuses. Companies should also consider not investing in technology where they think that the cost to rights would potentially outweigh any potential gains to profit or to security. The example of this would be facial recognition technology, something that large companies such as IBM and Microsoft have opted out of developing because they view the societal harms that could come as a result of this technology being fielded as greater than any potential profit they could themselves make. For technologists, they really should think about, we really should think about some kind of Hippocratic oath in our field. Don't always start out explorations into developing something with, can I build this? But really think about, should I build this technology? Is this something that can be later on abused by someone in a way that we're going to come to regret much later on down the line? And perhaps when it comes to choosing employment, evaluate companies for the work that they're doing right now and to consider not joining a company that to be abusing human rights or helping actors abroad and governments abuse human rights.
Can I ask, when you make this case to technology companies, what is their response? So I can imagine one possible response is, well, if we don't develop it, somebody else will. So it's better for us to be the ones who develop it and maybe get the patent and manage it and control it, rather than allow somebody else to. What do you say to those who say, who come back to you with that kind of response? How do you reply?
I think the responses are pretty wide ranging and depend on the culture of the company that you're talking to, and in many of these cases, it's really the belief system of specific founders, maybe the CEO, somebody who's very powerful in the company, who may hold all of the voting share rights in their dual, stock structure of their company. And so it's hard to, I would say, bottle up and say like there's one typical response that you get from companies. My sense is that the more enlightened ones see that we've come to a point where it's probably not worth making an additional dollar if you're doing that in a world where there's no longer democracy. And I think that the companies that do see that as a potential world that we could live in the near future are saying to themselves, we got to do better. We have to build tech for good. And we should try to avoid the things that we know are going to lead to wide-scale societal harm.
Is legal reform a part of that? So I know you're not a lawyer, so I don't want to ask you an unfair question. But it does strike me that part of the problem here is that there's very little, at least as you're describing it. You say we kind of want to encourage them to put their profit motive to one side. You said, and they should think about not just profit, but about like what are the long-term uses of this. And there's an alternative view, which is to say, that may be unrealistic to ask of profit seeking companies. If they have shareholders, I can imagine a response of a a CEO would be like that. My responsibility as a CEO is to pursue the best interests of the shareholders, and I'd be sort of ignoring my duty if I don't do that. And so one response to that could be, well, then let's make it costly for these technology companies to be developing these technologies and to be aiding and assisting in these human rights abuses, to be developing technologies that they know or should know could be used in these wrong ways and hold them responsible for it. Is that a piece of the puzzle that would be an important part of addressing this challenge of these technologies being put to bad uses?
Yeah, I certainly think so, Una. And specifically thinking about liability shields, things like Section 230 of the CDA as an area where potential reforms could lead to pretty large impact in the space where, especially with social media being so pervasive, it could have a wide-ranging, wide-scale impact on stopping some of these harms from happening. I think there's more and more appetite, it seems, in Congress and other places for some kind of common sense legal reforms with 230. I think that there have been some well-considered potential carve-outs that have been suggested, that have been put forth in Congress that would do some of this. And I think as an American citizen, kind of have to apologize to the rest of the world for where we've ended up, where, perhaps many parts of Section 230 have outlived its usefulness up to this point. And unfortunately, the rest of the world being subject to essentially this liability shield, they're going to have to wait for America to kind of, I don't know, clean up its act a little bit to try to push some of these reforms through.
So I want to turn now to encourage you all to speak to one another or respond to one another. I know we don't have a lot of time left. I wish we had all afternoon for this conversation, because even if we had all afternoon, we would have had a hard time talking through everything that we could. But it struck me that there's some common themes here, and I'd be interested in inviting you all to speak to them. I mean, Ibrahim and Radia, it strikes me that you are speaking about many of the same kinds of challenges that you're both facing in terms of bringing about accountability in a context where all these outside actors, states, are interfering in the conflict, are fueling the conflict, are making it worse, and the difficulties of holding those persons responsible. It seems like both of you are addressing at least what I heard here, addressing that challenge in a variety of ways. One is just gathering and collecting information and doing the investigations yourselves and trying to have some of this sort of making sure that this doesn't get lost or forgotten, as a kind of, even if we don't yet have the tools and ways of holding people accountable now, sort of a hope that we will. And in the meantime, we need to document and keep records of the abuses, so that when we do have a mechanism for achieving some form of accountability, we might be able to do that. I wonder if you could speak a bit to that, and also the roles in which, I mean, the International Criminal Court on the one hand is a great hope. On the other hand, it's significant limits on its jurisdiction. I mean, that sometimes it feels like an almost empty hope, and the kinds of concerns that you've run into there. And then Katie, I don't know if you want to comment on what you've been hearing here. I mean, in a way, obviously, a lot of your work under the Alien Tort Statute is about holding accountable those who have committed their abuses abroad, but have some connection in some way, shape, or form to the United States. In this case, of course, the abuses Abu Ghraib committed by Americans and American contractors, but outside of the country, and finding ways to hold them accountable under the ATS, which our viewers may know there's a Supreme Court case now pending that may raise the question as to whether the ATS is going to continue to be a viable option when it comes to not just foreign corporations, but US corporations. So mainly I wanted to invite you all to speak to some of the overlapping questions, and whether you see kind of commonalities to the challenges that you face, any hopes in terms of ways forward for addressing these kind of challenges. What do you see as the kind of next steps? And how do we think, particularly this problem of accomplices or aiding and assisting in violations. What can we do? What can viewers do to try and address that problem? And this is to any of you who wants to take it.
You can start, please.
Please go ahead, Ibrahim.
No, if you want, Radia, please go ahead.
Okay, I will talk about the documentation. Yes, it's one of the main things that we are doing in Muwatana, and we are in the ground. So in Yemen, there is a balance of weakness between all parties to the conflict that gives you a space to still be in the ground, even if the situation is very bad. So we have field researchers all over Yemen, and we are taking the documentation very seriously. We consider ourselves like responsible to build this human rights memory. At the beginning, we started to document for advocacy, but after years of war, we discovered the path of accountability because we have discovered that the war in Yemen, it's not like forgotten, it's ignored in purpose. So we have developed our mechanisms and a way and capacity in order to start to document for accountability, not only advocacy. So yes, we think this will, and the people themselves, the survivors, the families of those people who we are met, they give us, they cooperate with us, they give us all the details because they believe in justice also. Even the very ordinary people, they want to be told, they want their stories to be told, and they ask for justice. So we are doing this, and also having international investigation mechanisms help us also, because building files like what the IIIM is doing is very important, and it cannot be done by a local NGO. So that's why we also, part of our energy is going to push for these international investigations. Um, so to be also beside the work we are doing, and we want to document violations by all parties to the conflict all over Yemen, and it will help in the future, I hope.
Right. Ibrahim?
Yeah, I would say there is many challenges in our work actually. The main challenge for me is that most of the documentation is going outside of Syria, out the theater of the crimes. The regime didn't allow for any international commission or the IIIM to go and make any investigation inside Syria. And the difference now, we can find how it's effective they are working on the ground in Syria. The chemical weapon committee could go there and could collect direct evidence, and reports from them could identify who are responsible about this crime. For that, working outside, it's the main challenge for me. And besides that, how to protect the victim themselves and the witness. There is no mechanism, actually, clear mechanism to protect the victims and witness. Even if they wanted to take the risk to go ahead in this process, I don't touch like very serious mechanism to protect them, actually. And this is also making them thinking twice, because they are feeling there is no hope from the international community, because there is something going under the bridge, and they don't feeling that is fair for them. And for me, sorry for this, say this, but I don't talking about hope now. I am talking just about serious work, because serious work just brings what we want. The hope is just something Syrian people are looking for it for 10 years and nothing happened. For that, I'm always saying we should work hard and work hard, because we are can justify what we want. We can achieve what we want when we are working, just working. By hope, it's not enough. What we are doing now, it's very important in Europe, but still, it's small step in the long road for justice in Syria. For that, I am saying we are still in the beginning. We need more time. We need more experience as Syrian lawyers, as Syrian NGOs. We need more support. Even the international mechanism, it's not enough actually for me, because all their works is just to document and building cases. But what the next step for this files or this documentation, it's not clear actually until now. There is no open door for them to continue their work. So it's still the beginning for me.
Well, it is a that's a very honest answer. I mean, the problem is there are no easy answers to the problem that we face. And while we've seen some modest improvements in international law with a more robust interpretation of Common Article 1, for instance, and the obligation, the duty to ensure respect, not only duty to respect, and state responsibility doctrine has become more robust. This is a good reminder that the challenges really do remain, that it continues to be a significant barrier and battle to bring states and non-state actors to account. And thank you all for your work in doing that. Thank you for your important work and throughout your countries that you're working in and throughout the world to try and bring justice to victims of human rights abuses. And I hope all of our viewers will join continue the conversation. I understand there's a link at the bottom of your video. So many of the panelists will be able to join, and I hope that you will join as well so that we can continue the conversation then. So thank you, everyone. Thank you for your great contributions and for the fantastic conversation. And hopefully this is just the beginning.